curious, slightly challenging. When an employee gets hurt on the job in Louisiana, who is actually in control of their medical care? If you ask around, many agents will tell you not to worry. The common assumption is that the insurance company steps in, audits the medical bills, and automatically shields the employer from any excessive costs. But the math tells a different story. While employers wait for this supposed protection to kick in, plaintiff attorneys and their recommended clinics are using the company as a bankroll. Relying on standard industry inertia shifts the financial weight of the claim directly onto the employer's history. Without active oversight, the process defaults to the path of least resistance, higher billing, and longer durations. To understand why, we have to look at the baseline. In most states, when an on-the-job injury occurs, the employer directs the injured worker to a pre-selected, pre-vetted doctor. This flowchart compares that standard process to the Louisiana system. In Louisiana, the employee has the first move. Under the choice of physician rule, the injured worker holds the legal right to pick their own doctor. This right of choice applies to the first doctor in every medical specialty involved in the treatment. Because of this, an injured worker and their lawyer can quickly assemble an entire medical team. Often, this team shares a financial incentive to focus on long-term disability rather than a fast recovery. If an employer isn't actively managing these relationships through professional stewardship, they are handing a blank check to a provider who has no incentive to facilitate a return to work. Let's ground this in reality. Imagine a standard warehouse shift where an employee drops a box and strains their shoulder on the floor. If standard inertia takes over, that worker visits a specialist recommended by a billboard lawyer. Because these providers often prioritize the legal disability over the physical recovery, the resulting prescription frequently mandates time off instead of exploring what the worker can still do. This meter represents the experience mod. It acts as a driver penalty score for workplace injuries, and the National Council on Compensation Insurance tracks this penalty much like a credit bureau tracks a credit score. The moment that doctor writes a slip for lost time, the claim severity spikes. That single prescription inflates the employer's future insurance premiums for years to come. The standard defense tactic for an employer caught in this trap is to request a second opinion medical examination, or SOM, using a doctor of their own choosing. This diagram shows what happens next. The SOM doctor can't treat the patient. They only offer an opinion. If the two doctors disagree, the state appoints an independent medical examiner to break the tie, creating an administrative bottleneck. You enter a bureaucratic buzzsaw of legal costs and delays. It is like fighting a minor speeding ticket in court. The process of fighting it often costs more than the actual fine. Regardless of the final medical ruling, the moment you enter the state's dispute process, you have already lost the time and resources you were trying to protect. Some businesses try to bypass this entirely through subrogation, attempting to prove a third party is responsible for the injury and making them pay the bill instead. But waiting for subrogation requires complex legal wrangling. It adds another layer of delay to a claim that is already unmanaged. Any strategy that relies on waiting on the insurance carrier, the state examiner, or a third-party settlement is a losing strategy. The single most effective tool an employer has to bypass this state-level friction is establishing medical provider control before the injury ever happens. This requires pre-vetting a reliable clinic and building a foundation of trust with the workforce. The goal is to create an environment where the injured employee chooses to see the company's doctor first. When this happens, the employee visits an occupational medicine specialist. Instead of defaulting to disability, this doctor evaluates the worker specifically for their functional capacity. This timeline maps the difference. Because the Occ-Med doctor focuses on light-duty capabilities, the worker is given tasks they can safely perform while recovering, meaning they never miss a day of work. The claim stays classified as medical only. This avoids the lost time penalty, protecting the experience mod and the company's bottom line. Businesses do not win these claims because they bought a better insurance policy. They win because they decide to be the most active player in the room. The legal application of these rules is messy, but you cannot let your business drown in unmanaged medical bills just because the system is complex. Agents who want to master these protocols and protect their clients can learn the process at the Institute by visiting workcompprofessionals.com. And employers ready to bypass the friction and take immediate control of their own claim costs can start right now at lockedandloadedtraining.com. Fortune favors the bold, but it favors the one who takes action. It's your move.